Welcome to the Assembly Committee on Legislative and Operations. Thank you for being here at 3:30 all. Will the Secretary please call the roll?
Assemblymember Cole. Dickman. Edgeworth. Gonzalez. Hibbets.
Here.
Howdigi. Miller. Monroe Marino.
Here.
Sorry. Moore. Nadim. Chair Mosca.
And I am here, if we could please mark Assembly Members Gonzalez as well as Assemblymember Miller here as they arrive. Welcome to the audience in Carson City, those joining by video conference in Las Vegas, and those listening over the internet. I didn't say it last meeting, but we also have Mr. McDonald is here, who is our committee counsel, who's usually in Las Vegas, but here in Carson City this week. So make sure you say hi to him. And before we begin, I'd like to make several housekeeping announcements. Please silence your electronic devices. If you wish to testify, please sign in at the table by the door and provide a business card to the committee secretary. When testifying, please turn on the microphone and clearly state and spell your name and state any affiliation for the record. This helps our committee secretaries who take the notes and turn off the microphone each time you're done speaking. There are hard copies of the meeting materials available for the public. Members of the public may also access electronic copies of the materials on the Nevada Legislature's website. Public comment will be taken at the end of the meeting. Each person will be limited to 2 minutes. In addition, the public may submit written testimony to the committee up to 24 hours after the meeting. We expect courtesy and respect in our interactions during the meeting, even if we may not agree with one another's positions. And finally, committee members will be using their laptops to view handouts and other documents. Please do not view this as a sign of disrespect or inattention. And with that, we will get ready. I will now open the hearing on Assembly Bill 79. This measure revises provisions relating to campaign finance, and we have the Secretary of State's office. Please limit your presentation to 15 minutes, and you may begin when you are ready.
Good afternoon, Chair Mosca and members of the committee. For the record, I'm Cisco Aguilar, Secretary of State. It is a pleasure to be here with you today in Las Vegas. I am joined by Chief Deputy Gabriel DeCara in Carson. We're here today to provide you an overview of Assembly Bill 79 and then take your questions. As you have heard me say, my 3 guiding principles for the upcoming biennium are modernization, innovation, and transparency. This bill is heavily focused on transparency. Campaign finance laws are generally contained within Chapter 294A of our revised statutes. That chapter is critical to my role as a regulator because it ensures an even playing field for all individuals and candidates and PACs who wish to be involved in the political process. Additionally, responsible campaign finance laws enables the public to see and understand exactly what goes on with campaigns. It shows them who is funding each candidate and what those candidates are spending their money on. That information helps voters understand candidate priorities and influences in a way that a simple flyer in their mailbox or a 20-second ad on YouTube cannot, making it an extremely important part of the electoral process. It is also an important resource for the press, who pass that information on to the public. Assembly Bill 79 has a few main elements, which are as follows. 1, proposes to clarify what a PAC can spend money on. 2, there are situations where certain candidates and former public officials have to dispose their remaining funds. This simply requires them to notify the Office of the Secretary of State once they do, which will help with oversight. 3, provides clarifying information about how campaign funds can and cannot be spent. Under the proposed amendment, would use the same standards as the Federal Elections Commission. 4, revises the definition of a committee for political action for clarity. 5, requiring that any candidate who receives $100 in donations before the candidate filing period file a notice of intent to file for candidacy with the Secretary of State. And 6, a provision that relates to compliance. Campaign finance complaints are regularly filed with the office and require significant investigation to determine whether or not a violation has occurred, even before a fine is issued. This process should be clarified and streamlined. I'll now turn it over to Chief DeCara to talk through the proposed amendments. Thank you.
Thank you, Mr. Secretary. I will now go over the proposed changes described in the conceptual amendment provided. These were generated by a number of conversations with seated officials, former candidates, organizations, and other stakeholders whose input and collaboration we very much appreciate. First, the proposed amendment to Section 2 would remove the current language and replace it with a similar definition of what spending is authorized by a PAC. Second, the proposed amendment to Section 3 would keep the same intent, but would instead use the irrespective test used by the Federal Elections Commission. We firmly believe that in certain circumstances, the use of campaign funds for things such as child or elder care are more than appropriate, but the most effective way to do this is by formalizing the FEC standard. Notably, the FEC does allow candidates for office to use campaign funds for child care and has since 2018. The proposed amendment to Section 6 is still a definition, albeit a slightly different one that is more state-specific. For Section 7, the proposed amendment removes the requirement to identify which office the individual intends to run for, recognizing that those decisions may be fluid. What's important is that the Secretary of State is notified that fundraising has begun, which triggers oversight. The proposed amendment for Section 11 removes the previous language and instead proposes to create a hearing process similar to the one in place for the Securities Division within the Secretary of State's office. This will both assist with the recovery of funds and build in an independent appeal process for candidates or officials who feel that their fine is inappropriate. And finally, the additions propose to clarify contribution limits for special elections, that they are capped at $5,000, to more clearly state that candidates may collect $5,000 for a primary and $5,000 for a general election, regardless of the number of candidates, to add clarifications about the Secretary's authority to waive or reduce civil penalties relating to required financial disclosure statements and contribution and expense reports, clarifying that the Secretary will publish a list of those who are delinquent on civil penalties, but also formally authorizing payment plans. And finally, amending NRS 294A0035 so that the list of campaign expenses aligns with a very similar list in NRS 294A365. And that includes the summary of the amendments. Thank you.
Cisco Aguilar, Secretary of State. Transparency is such a critical part of our electoral process and ensuring that voters are comfortable and confident with their choices. Thanks for allowing us to present Assembly Bill 79. This concludes our presentation. We look forward to any questions or comments. Thank you.
Thank you for that quick but detailed presentation. So with that, we will go to questions. Members, any questions? Yes. We'll start with Assembly Member Monroe Moreno.
Thank you, Madam Chair. I'm looking at the amendment, and in Section 7 of the amendment, it's amending that an individual no longer has to specify which office that they're running for, their intent to run for. Why make that change?
Thank you for the question. Gabriel DeCara for the record. We know that the decision about what office to run for can change a number of times, especially before candidate filing, but after fundraising has begun. If we were to leave that form, leave the office on the intent to file form, it would potentially cause the candidate to file a number of forms with our office when what's important is not necessarily what office they're running for, it's the oversight of the funds that they're gathering. If you change what office you intend to run for, you aren't required to give money back to donors, et cetera. So the oversight portion is what we wanted to focus on. Thank you for the question.
Thank you for that. So once the intent to run, they can campaign and raise money the entire time, but once they actually file for a specific position, that's when they can only raise money for that position. They need to tell their donors at that time?
Gabriel DeCara for the record, thank you for the question. Both statute and regulation are silent on what must be communicated to a donor if a candidate were to change the office that they intend to run for example. Although yes, if a candidate has filled out their declaration of candidacy. They are a candidate for that office. They continue to raise funds. They can no longer change the office they're running for at that point. I suppose theoretically they could decide to hold on to those funds and not spend them because they intend to run for another office in the future. However, both this bill as well as Speaker Yeager's bill are attempting to clean up the process for the disposition of funds after a candidate loses. So if they're not spending that money on that race, they become, and they're defeated in that race, they have to follow those specific requirements for the distribution of funds.
And just to get it on the record, how long does a candidate who failed in their race for an office have before they have to disperse with the funds in their campaign account?
Thank you for the question, Gabriel DeCara. For the record, Deputy Voloshin is presently in the Senate for the work session of our bill. He would know offhand. I believe it's not later than 15 days of something in December. I apologize. However, there are a number of exceptions, and those exceptions include accepting another $100 donation makes you a candidate again. And whether or not you have to dispose of those funds is not something that has been very clear. So we're focused on cleaning that process up. Thank you.
Thank you. Next, we'll go to Assemblymember Hibbets.
Thank you, Chair. So I've got two different proposed amendments in front of me, one from your office and one from the chair. And let's put the second one aside for a second. If we were to pass this bill as proposed, with the proposed amendment, and we also passed AB 497, we would actually be passing two conflicting laws that don't mesh together, even though they're talking about the same thing. So, and I'm not saying that we would do that because our body is a little better than that, I would hope. So my question is, what is the ultimate goal here so that we as a body can come to a decision as to which, if either bill needs to be passed, or if we need to make more amendments like the second one that I have in front of me?
Thank you for the question, Gabriel DeCara. For the record, we don't necessarily see the relationship between AB 79 and AB 497 to be in conflict, although there are some different changes similar to the same statutes that are requested. I believe that our goal, the goal with our bill is the same as Speaker Yeager's goal with his bill. We want to improve on the transparency of the electoral process and provide important clarifications on how campaign funds must be spent and reported. That's everything that we're trying to do here. And as we said, we're very open to amendments, to harmonizing whatever bills and whatever ideas come out of this committee, out of the Senate side, et cetera. The goal is just to create more transparency for the public. Thank you.
Next, we'll go to Majority Leader Hadegui.
Thank you, Chair, and a quick question on the amendment. Let me make sure. It was on, let me find the section, it was on the special elections being capped at 5,000, so it's in the additions section. So NRS 294A, that 100, can you tell me, does that apply to all elections? So whether it's like school board, city council, legislative, because a $5,000 limit across the board, and is that $5,000 per contribution or a $5,000 limit in total raise?
Thank you for the question, Gabriel DeCara. For the record, so I'm trying to find it. So 294A100 says that the contribution limit for an election is $5,000 for a primary and $5,000 for a general election. The statute does not address special elections, which are neither a primary or a general, and that statute has been interpreted differently across different administrations over the decades. Secondly, something that has been consistent in the Secretary of State's interpretation, but is not in statute, is what happens if you do not have a primary opponent. That is not something you have control over when you file your declaration of candidacy, and candidates should not be penalized for not having an opponent. So even if you don't have an opponent, you can still raise $5,000 for the primary election, making the limit for both the primary and the general $10,000. Does that answer your question?
It did, thank you.
Okay, thank you.
Okay, thank you. I do not see any other, Assemblymember Cole.
Hello, thank you for this. So my question is in section 3 of the bill where we're talking about the ability to spend unspent contributions to pay for the cost of childcare, care of an elderly parent. I think, and a few other things, I think you had mentioned that that aligns with some federal regulations and whatnot. Is it solely what is allowed under federal, or did you make some changes to that based on other things? And then asking for a friend who might be a small business owner who got elected, how about money for paying somebody to run my businesses?
That is an excellent question, Gabriel DeCara, for the record. So what we have put in place is, what we are asking to put in place in the amendment is the same irrespective test. So if a cost would have existed irrespective of your campaign or time in office, then it cannot be paid for by campaign funds. We made the decision not to spell out in statute some of the things that qualify, for example, childcare, elder care, health insurance, et cetera. Although we do believe in certain circumstances those things do qualify, we would like to have the ability to provide perhaps some of that clarification and regulation, so there's some flexibility and the statute is not locked in. But that irrespective test that the FEC uses is something that has been kind of, it has been used unofficially by a number of campaigns and the Secretary of State's office in the past, and we felt it would be best to formalize that so you don't need an attorney who knows FEC law. If you're a candidate, you'll be able to see it very clearly spelled out. This is how expenses, this is how campaign funds can and cannot be used. Thank you.
Okay, thank you. And with that, we will now open it up for testimony. Thank you. Today, we will be limiting testimony to 30 minutes, so 30 minutes of support, 30 minutes of opposition, and 30 minutes of neutral. Don't forget you can say ditto, and again, you can submit your full written testimony up to 24 hours after the meeting. So we'll first open it up for testimony in support of Assembly Bill 79. Each person has 2 minutes. Please keep your comments to the bill and not the bill sponsor. And members of the public can also call over the phone at 888-475-4499 and enter the meeting ID 835-8899-2343. And with that, we'll start here in Carson City for testimony in support of Assembly Bill 79. Seeing none, we will go down to Las Vegas, support of Assembly Bill 79. Make sure, don't see anyone. Maybe. Okay, thank you. So with that, we will go to the phone lines for support Assembly Bill 79. Thank you, ABH.
If you would like to testify in support of Assembly Bill 79, please press star 9 to take your place in the queue.
Good afternoon, Chair Mosca and members of the committee. For the record, my name is Ryan Bordish. That's spelled R-Y-A-N, last name V-O-R-T-I-S-C-H, and I am the Northern Nevada Democracy Coordinator of Silver State Voices. I'm here to testify in support of AB 79 on behalf of my organization and the Let Nevadans Vote Coalition. The size of an elected officer's personal wallet should not be a barrier to serving office, yet, especially in our legislature, we are seeing turnover due to the lack of benefits and livable wages. AB 79 helps to address this problem. Personal expenses like childcare or health insurance premiums are not luxuries, but basic necessities. Many Nevadans are parents, live in multi-generational households, or don't have bottomless pockets. At Silver State Voices, we are in strong support of AB 79 because we believe it offers a pathway towards a truly representative democracy where people from all walks of life are able to run for office. Nevada's diverse communities deserve accurate representation, which is only possible if our elected officers have the resources to afford basic fundamental care. We appreciate the Secretary of State's office for bringing this issue forward, and I urge your support on AB 79. Thank you.
Thank you. AVH, next caller.
Hello, members of the committee. My name is Paula Luna, that's Paula-Luna, and I'm the Deputy Director of Battleborn Progress. And I'm calling in support of AB 79. We should be taking a holistic approach at Canada's expenses and easing up any burdens for our community members who want to run for office. AB 79 does just that, and we urge your support. Thank you so much.
Thank you. AVH, next caller.
If you recently joined the call and would like to testify in support of Assembly Bill 79, please press star 9 now to take your place in the queue. Chair, we have no additional callers in support at this time.
Okay, thank you so much. With that, we will now open up opposition for Assembly Bill 79, and we will start here in Carson City. Don't forget to state and spell your name for the record, and you'll have 2 minutes.
Thank you, Madam Chair, members of the committee. My name is Janine Hansen. I'm the state chairman of the Independent American Party. I don't have a problem with using campaign contributions for babysitting or taking care of an elderly parent or health insurance. My concern that I wanted to share with you today, and opportunity with this, is just the constant increasing numbers of reporting requirements. The Secretary said that this creates an even playing field. Well, it actually doesn't. It changes things significantly. One of the reasons for that is because even though there's more and more and more reporting, there's also more and more and more dark money. There's also problems that happened to me. When I ran years ago for state senate, I had a lot of people that were from other political parties that wanted to give me money. But they would say, oh, well, Janine, we can't give you more than $100 because then our name would go on the Secretary of State's website and we would get persecuted by our party. So what these rules do, especially for third parties and also for people who are not anointed by their own party, is it suppresses anyone that wants to oppose the establishment, those that are the reigning people in charge. And that's precisely what these rules do. They don't help anyone. They don't improve the election. There's so much dark money, it doesn't make any difference. But they do suppress money coming to honest candidates from all political parties, and especially from third parties that want to participate in the election. So my statement is just a general one of my concern over increasing candidate requirements. And the other thing it does, it discourages people from participating because there's more and more and more reports. And a lot of my people aren't capable of constantly doing those reports without help. So I don't think it helps the political process, but it harms it. Thank you.
Thank you. Seeing no other opposition here in Carson City, we will move to Las Vegas for opposition of Assembly Bill 79. And seeing none in Las Vegas, AVH will open up the phone lines for opposition of Assembly Bill 79.
If you would like to testify in opposition of Assembly Bill 79, please press star 9 to take your place in the queue. Chair, we have no callers wishing to testify in opposition.
Okay, thank you. And with that, we will open it up for neutral. If you are here to testify in neutral of Assembly Bill 79 in Carson City, don't forget to state and spell your name for the record, please.
Thank you. Good afternoon, Chair and Committee. My name is Joshua Skaggs, Joshua Skaggs, and I'm the Legislative Affairs Director for the Nevada Republican Party here in neutral on AB 79. We did support the common sense limitations on personal use of PAC money specified in Section 2, and we're sorry to see that language deleted. We were opposed to Section 6 of this bill for many of the same reasons that we opposed AB 497, which also proposes excluding nonprofits from political disclosure and reducing transparency in our elections. With the deletion of Section 6, we are changing to neutral, pending our review of the new language added in the Secretary's amendment. Section 6 of AB 79, like AB 497, would have eliminated certain nonprofit organizations from the definition of a political action committee for campaign finance purposes. This clarification to exclude nonprofit organizations create transparency concerns as it encourages a major expansion of dark money in our elections. 501c4 nonprofits in particular are allowed to engage in an unlimited amount of political lobbying as long as that lobbying is related to their exempt purpose. They are also allowed to engage in political campaigns as long as such involvement doesn't constitute their primary activity. Some 501c4 organizations are very large and could be a major player in political campaigns even if they fell below the quote primary activity bar. Because of this, we will reserve the right to oppose any provisions that allow nonprofit organizations to avoid disclosure. Thank you.
Thank you. Seeing no others here in Carson City for neutral, we'll go to Las Vegas for neutral of Assembly Bill 79. And seeing none, AVH will open up the phone line for Assembly Bill 79 in neutral.
If you would like to testify in neutral for Assembly Bill 79, please press star 9 to take your place in the queue.
Hello. I meant to call during the support and I was accidentally listening to the wrong hearing. Is there any way I could give support testimony?
Because we did not reach our 30-minute block of support, you can, yes. You have 2 minutes. Please state and spell your name for the record.
Okay, thank you very much. This is Carissa Pierce, CarissAPearce with Children's Advocacy Alliance. I wanted to just give our support to AB 79, and thank you very much.
Thank you. AVH, any other callers for neutral?
If you are here for neutral for
If someone is speaking, we cannot hear you.
You are in the meeting now.
And we will be at ease. We're having some technical difficulties. We'll be at ease. Thank you.
and unmuted to the street.
Okay, thank you, everybody, for that brief fixing of technical issues. So thank you, AVH, and all of our technical staff. We're back up, and I believe there were no callers. There were no callers in neutral. Okay, with that then, excuse me, I will invite the Secretary of State up for closing remarks.
Thank you, Chair and members of the committee. We just want to say thank you for your time, and if there are additional questions or clarifications, our office is always available. Thank you.
Okay, thank you. And with that, I will close the hearing on Assembly Bill 79. This is the Secretary of State Day, so I'll now open the hearing on Assembly Bill 534, which revises provisions relating to elections. In the Secretary of State's office, when you are ready, you may begin.
Well, good afternoon again, Chair Mosca and members of the committee. For the record, I'm Cisco Aguilera, Secretary of State. As always, it's a pleasure to be here today. I'm joined by Chief Deputy Gabriel DeCara. We are here today to present Assembly Bill 534 and then take your questions. Before we get to the bill, it is important to get on the record a few major differences between this elections bill and Senate Bill 74, which you hopefully will be hearing later on in the session. That other bill, SB 74, is our elections cleanup bill. It was developed in close coordination with county and city elections officials going back to 2021, as the Secretary of State's office has worked to identify those statutes that could benefit from being updated to meet the needs of modern elections. Assembly Bill 534 is a bill based on internal and external feedback from the most recent election cycle and my own experience. This was the first cycle where I have served as Nevada's Chief Elections Officer, and there are places where I'd like to see the law improved. This bill will also be amended further in conversation with the counties and other stakeholders, so we remain very open. I'm going to turn the presentation over to Chief Deputy DeCara now, though as always, both he, Deputy Velashan, and I will be available to talk with you now or on one-on-one basis if you have questions about any specific element of this bill.
Thank you, Mr. Secretary. Good afternoon, Chair Mosca and members of the committee. I'm Gabriel DeCara for the record, and I serve as Nevada's Chief Deputy Secretary of State. Assembly Bill 534 proposes changes to a number of different sections of NRS 293, and while each of them are important and the product of careful deliberation, I want to focus on a few key provisions. First, Assembly Bill 286 of the 2023 legislative session created a means for eligible but incarcerated individuals to vote from within jail and correctional facilities. And to be clear, that bill did not apply to convicted felons in prison who lost their civil right to vote pursuant to state and federal law. The Office of Secretary of State received feedback regarding the implementation of that bill, and while the county and city jail administrators worked very hard to implement it, they did identify challenges. So to start, Section 2 proposes to allow incarcerated but eligible individuals the opportunity to use the same system used by our military and overseas voters. Doing so will retain the security of the process while decreasing the administrative and logistical burden on voters, elections officials, and jail administrators alike. There are also provisions that amend reporting requirements for jail administrators and a requirement for procedures to be codified in regulation upon approval from the Legislative Commission. Presently, there are two types of provisional ballots in NRS 293. Sections 5, 23, 26, 32, and 38 through 37 of the bill propose to name one of them from provisional to conditional to reduce voter confusion. The first type of provisional ballots are federal provisional ballot required by the Help America Vote Act and NRS 293 3078 to 2086. A federal provisional ballot is a ballot issued to a voter who claims to be a qualified elector, even if they do not show up on voter rolls or have their information to prove their eligibility. The election worker or clerk is required by federal law to issue them a ballot or allow them to vote. This federal provisional ballot is considered a fail-safe ballot that the voter is provided, but it is not tabulated until after they provide proof of eligibility. And if they do not provide that proof of eligibility by 5 p.m. on the Friday after Election Day, the ballot is not counted, again, required by federal law. Those ballots will keep the title provisional ballots, as that is the federal requirement and how they're referred to in federal reporting. The second type of provisional ballots, governed by NRS 293 5772 to 5887, are addressed by Section 4 of the bill. This change is intended to do two things. adjust statutory requirements to take advantage of the new top-down system that we have in place as a result of the VRM's project funded by this legislature, thank you very much, as well as reduce the casting of provisional ballots during an election. Under the old system, when a voter moved to another county and then updated their registration, in certain circumstances, that voter registration was considered brand new, even if the voter had lived and voted in Nevada for decades and their ballot was designated as provisional, which triggered the federal requirements previously reviewed. Now, under the top-down system, that change would simply be viewed as a voter registration update. They would not have to cast a provisional ballot, as the required information has already been provided to one of the counties in the state of Nevada. The voter's identity has already been validated. Again, all existing security and proof of identification and residency requirements remain the same, but this change will decrease the number of ballots referred to as provisional ballots to save the county's time as they process ballots for the election. Currently, candidates for elected office have two separate and distinct filing periods, one during the first 2 weeks of January for judicial candidates, and another in the first 2 weeks of March for non-judicial candidates. Sections 9 through 11 and 58 and 59 propose to consolidate those into one filing period in the first 2 weeks of February. There are two goals here. One is to help reduce the number of candidates on the primary ballot who were A, successfully challenged in court, but B, still show up on the ballot due to the timelines and logistics of ballot printing. And moving the non-judicial filing period back a month would give the courts more time to adjudicate challenges, which would allow county clerks to ensure that those candidates are removed before those ballots go to print. There are also similar adjustments made to the filing periods for independent candidates for presidential office. Also, having a single filing period would help the county and city clerks so that they did not have to stand up a filing period, take it down, and stand up a second filing period 2 months later. Section 14 of the bill authorizes the Secretary of State to adopt regulations relating to standards for certain reports with Legislative Commission approval to clarify the requirements for both election officials and the public. As we modernize our election system, we need to be sure that everyone is releasing the same information in the same format to enable a sensible flow of information. Section 18 addresses a concern that was raised repeatedly by voters in the 2024 cycle. Existing law allows a voter to opt out of receiving a mail ballot up to the 60th day before the election. Many individuals did so, but then circumstances changed that led them to need a ballot, for example, a trip or a hospitalization. This statute would allow a voter who previously opted out to opt back in up to the 14th day before the election. Sections 22 and 55 allow for additional time to conduct pre-election tests of election equipment. As counties continue to grow and more voting systems are needed, there's a need for more time to properly conduct statutorily required tests of voting systems and electronic rosters, or poll pads as we call them here in Nevada. These sections change the timeline from 2 weeks to 6 weeks before the first day of early voting. Sections 24 and 33 define the term personal knowledge, which is used in relation to certain challenges. This will help clarify for the public and courts what constitutes a lawful challenge of a voter's eligibility and what is not acceptable as justification for the possible revocation of someone's constitutional right to vote. Section 30 clarifies that the term canvass, when used to mark the starting point for a recount, also includes U.S. Senator or representatives in Congress, which had been previously unclear. And again, we have heard from a number of stakeholders about this bill. We anticipate further discussion and amendments as it moves through the process. Back to you, Mr. Secretary.
Thank you, Gabriel. And thank you, Chair, for allowing us to present Assembly Bill 534. This concludes our presentation. We look forward to any questions or comments. Thank you.
Thank you so much. We will open it up to questions. Members. Okay, great. We will start with Assemblymember Nadeem.
Thank you, Madam Chair. Thank you for the presentation. I just want to need some more clearance regarding opt-out and opt-in. So can you kindly explain it a little bit? Thank you.
Yes, absolutely. Presently, under law, I believe, Mark, which bill was it?
That was in 321.
AB 321, the Universal Mail Ballot Law. Voters can opt out of receiving a mail ballot. However, when that statute was instituted, there's no way for them in statute to opt back in presently. So a voter who had opted out because they did not want a mail ballot had no means to receive one if they changed their mind later on. We would like to see that amended. Thank you for the question.
Thank you. Next, we'll go to Assemblymember Dickman.
Thank you, Chair, and thanks for being here. It's good to see you. I just was thinking about all there is in this bill. And I'm wondering how difficult this might be with all the changes in deadlines, kind of moving targets. Is this going to be really hard on especially the rural areas, the clerks? How are they going to have time to adapt to all these changes? I mean, do you think they'll be able to meet these deadlines?
Gabriel DeCara for the record. Thank you for the question, Assemblymember Dickman. So we know how challenging it is for the county clerks to keep up with all of the responsibilities that they have in their offices, especially in areas, some of the rural areas where they may be have a difficulty having or keeping staff. We don't want to discount that at all. I will say, what we are aiming to do with changing a number of these deadlines is to give them more time. So potentially some of the changes that we're asking for in terms of when petitions can be turned in. Again, we expect that this language will need to be amended, but our goal is to give clerks more time to be able to administer elections so that someone can't turn in a petition the day before the election, and the clerk has to not only fulfill all of their statutorily mandated election duties, but also get those signatures validated, begin the process of processing that petition. So while there are a number of timeline changes, and some of those may change when some of the clerks have to fulfill some of those duties, we are trying to look at the elections calendar as a whole, remove requirements where they're not necessary or helpful. For example, moving back that testing of machines, that will help the clerks greatly in advance of election day. So under no circumstances do I want to say that I think it would be easy, but we will do our best, and we're doing our best with this bill to help them manage the totality of election administration.
Could I follow up, Madam Chair? Yeah. So will the rural, if they need more resources, will there be resources available to them as far as financial or, personnel or?
Gabriel DeCara for the record. Thank you for the question. Yes, absolutely. One, the Secretary of State's office throughout this past election cycle, not just as part of the VREMS project, but also more broadly, we have always sought to help the clerks with anything that we've needed. We have sent our own staff to serve as poll workers to rural areas where they were not available. We have shown up as on-site technical support when clerks felt that they needed that kind of support. We will, under Secretary Aguilar's guidance, we will continue to support the clerks throughout the election process. We are also working with Assemblymember Gonzalez on a bill that would create a grant fund, specifically in the Secretary of State's office, that could accept gifts and grants that would enable us to further support clerks financially. So there are requests that come to us this past cycle. We helped counties pay for ballot sorter machines, for example, because they needed the help, so we stepped in, and that will not change.
I saw that beautiful ballot sorting machine in Washoe. Thank you. Thanks, Chair.
Thank you, Chair, and thank you for the question, Assemblymember. Mark Vlashin, last name spelled W-L-A-S-C-H-I-N. The only other caveat I'd like to add to what Chief DeCara mentioned was in regards to the implementation, recognizing, as he said, that the county election officials have so much on their plates. We really continue to go out of our way to think, how can we make it as easy as possible? We will build, for example, calendars that show just the before and after of timeline changes specifically. These things happen a couple days every other year, in some cases every 4 years. Those sorts of changes, we don't want an election official to think back and remember in 22 or 20 and then get confused. So quick reference guides, reminders. We do have phone calls twice a month that we talk about things and really look to the next 30 to 60 days. But we really try to, we have staff on the Secretary of State staff who have county election experience, but we will continue to try to put ourselves in their shoes, ask for their guidance and what can we do to help. And then, not do that the day before the due date, of course, but really, already we're doing that to set them up for success so that as they are right now focused on supporting the needs of their constituents, we are developing documents, guidelines, checklists, the elections calendar, so that as we prepare for the 26 election cycle, we'll have these resources that they can pin to the wall, reference quickly, and make sure that they're complying with both statutory requirements as well as providing that information to their constituents and voters.
Thank you. Next, we have Vice Chair Gonzalez.
Thank you so much for the presentation. I was just wondering for clarification if you could talk about how incarcerated folks are voting and then how the ease would change that.
Thank you for the question, Assemblymember Gabriel DeCara. For the record, so presently under AB 286, incarcerated individuals have a few different options for voting. They must be provided the opportunity to either vote using their mail ballot or at their request to utilize a voting machine. Different counties dealt with that request in different ways. Some set up a voting machine in their a jail or an area nearby the jail. Some provided for incarcerated individuals to travel to a location where there was a polling place set up. And in terms of voting by mail, there were very strict requirements about how the mail ballot could be provided to ensure that there was no interference with the ability of the incarcerated individual to vote. And we do feel that that worked successfully, although, as we said in the presentation, not without challenges. The reason why we are asking for the ability to allow for the ease system to be used is that some of those challenges are difficult to overcome. For example, if an individual is a registered voter in one county but is in jail across the state, and the county is not able to get them a mail ballot in time, the jail has two options: to either transport that voter all the way across the state solely for the purposes of them voting, or not allow them the right to vote, which would not necessarily be in line with the law. However, utilizing the ease system would allow any voter from any county to securely sign in, securely cast their ballot, have it go to the county in which they are registered, where it would be validated and then tabulated. And it could all be done with a laptop that's set up to only go to just that one website. We feel that this would help alleviate some of the burden that we heard about from jail administrators, as well as simplify the process for individuals who, again, may not be incarcerated in the county where they reside. Deputy Voloshin, did you want to add anything? Okay, thank you.
And thank you so much for that explanation. And you said jails. Does this include prisons as well?
Thank you for the question, Vice Chair Mark Voloshin, for the record. So it is limited to just the jails right now, though certainly it is our understanding that there occasionally are situations where eligible but incarcerated voters are sent to prisons, in some cases because of capacity at the jails themselves. So there still may be opportunities. So it's certainly something we're willing to explore and make sure that, again, bottom line, if an eligible voter, regardless of the situation that they're in, if we need to work with the prison systems to identify and allow that exact smaller population of the prison, it's certainly something that would be possible without creating an additional logistics burden for the counties.
Thank you.
Thank you. Next, we'll go to Assemblymember Cole.
Thank you, Chair. So my question is in section 24 when we're talking about challenges. So I'm looking at section 24 sub 1A, and this is existing language where it talks about that the challenge is based on the personal knowledge of the registered voter who's initiating the challenge. And then your change towards the end of section 24, in fact, it's subsection 10, you've made a very distinct definition of what that personal knowledge means and what it doesn't mean. And I guess my question is first, what is the purpose of having a personal knowledge in challenging a voter? And it's based in the precinct is the way that I look at it. So it's a very small subsect, like personal knowledge with somebody in the precinct. So what's the purpose of that personal knowledge, and why do you feel the need that you need to whittle it down? Thank you.
Thank you for the question, Assemblymember Gabriel DeCara, for the record. So the purpose of voter challenges and the personal knowledge statute is if you see someone voting that you personally know is not eligible to vote, there should be a legal mechanism by which you can challenge their vote, and that there is a legal process that that voter has to go through to either prove that they are eligible or in fact lose their eligibility and deal with whatever legal consequences potentially come from that. That being said, I agree with you completely. That personal knowledge based in the precinct, our understanding, our interpretation of the statute and what we're trying to clarify in the law is that really is personal knowledge. That means it's someone that you know in your community that should not be eligible to vote. What we have seen over this past election cycle is individuals using information gathered from databases and saying that, well, I have personally seen the information from this database. And as I have seen the information from this database, I believe that this voter is not eligible. The Secretary of State's office provided guidance over the course of the election to the county clerks that this was our interpretation of the statute based on a conversation with the Attorney General's office. And we believe that that should be put into statute, again, to clarify that personal knowledge really should be personal. Thank you for the question.
Next, we have Assemblymember Nadeem.
Thank you, Madam Chair. Thank you so much for explaining it so well. I just have a question. When you say rename certain instances of provisional ballot to conditional ballot, can you kindly give us some example to better understand it?
Gabriel DeCara, for the record, yes. So for example, under the old system and in this previous election cycle, a voter who moved from Clark County to Washoe County had to re-register in Washoe County. They had to provide all of the necessary information. Let's say they showed up to vote. They had not yet gone through the whole voter registration process, had not provided all the necessary documentation, but they were already a registered voter in Nevada. Doesn't matter. Under existing statute, they would be given a provisional ballot. They would have to do the ballot cure. They would have to prove their eligibility to vote. And if they did not prove that by the Friday after the election, that vote would not be tabulated. Now, because we have this new top-down system, it is very easy for us to confirm that an individual is who they say they are and simply move their voter registration from one county to the next. Those still need to be reviewed, and so we would change that to conditional ballots, but we don't feel that they should have the same strict requirements as what are federal provisional ballots. Thank you.
Members, any other questions? Okay, seeing none, I'm actually gonna ask a question similar to what I asked on Tuesday, sorry. I know we hear about clerk workload a lot, and so we are moving to the VREMs and the top-down system. Do you see any of this alleviating workload, or how do you see it working together?
Thank you for the question, Gabriel DeCara, for the record. I certainly hope so. I think one thing that we are trying to do to alleviate some of that pressure relates to reporting. We know that more and more voters in the press want access to information as it comes in, and kind of what can happen. What has happened previously is a lot of different people reaching out to the clerks asking for a lot of information that is not always easy to provide immediately. What we are seeking to do with this bill is not just standardize some reporting, but that allows the Secretary of State's office to build that reporting into the top-down system so that clerks don't have to handle all of those reporting requirements themselves. In conjunction with the state, the reports have been built, they simply have to be pulled, and the information can be given to the public. So that's just one example of how we feel some of the workload would be alleviated. Deputy Voloshin, do you have anything else you want to add?
Absolutely, Chief. Thank you for the question, Chair Mark Voloshin, for the record. Additionally, the timelines, I think, are a very critical component. As the state continued to grow, those timelines remain the same for validating signatures, those sorts of things. The goal is again, to reduce the urgency of some of these requests. Validation still has to occur. Of course, those sorts of things and a number of other provisions touch on the timelines as well. But by adapting to meet the realities of our population currently, that will ultimately reduce some of the urgency for the counties so that they can focus on the election, focus on the various tasks appropriately, give them the attention that is due. But again, instead of such a compressed timeline, and again, the goal is to overall reduce the workload by spreading it over an appropriate amount of days. But yes, the bottom line is that exactly what you touched on. How do we address the workloads across the state, counties, and cities without adversely affecting voters, without, reducing opportunities for the voters to be able to vote in person, again, in the manner of their choosing during either the early voting period or on election day is constantly something that we're thinking about and trying to get our hands around.
Gabriel DeCara for the record, just one thing to add, and again, we do not see the timelines that are written to this bill right now as the final timelines. We understand that there may need to be amendments. This was a bill that was filed late and came to us recently, so there are still a number of conversations that need to happen, and we are very open to making those adjustments as necessary. Thank you.
Thank you. Okay, and with that, we will now open up testimony. We'll limit testimony to 30 minutes, 30 minutes in support, 30 minutes in opposition, and 30 minutes in neutral. You will have 2 minutes to provide your testimony. Make sure you're talking about the bill and not the bill sponsor. And for those who are going to call, the number is 888-475-4499, and the meeting ID is 835-8899-2343. So we will start here in Carson City for support of Assembly Bill 534. Don't forget to state and spell your name for the record.
Chair Mosca, Vice Chair Gonzalez, and members of the committee, Esmeralda Vasquez, ESMERALDAVAZQUEZ, with Strategies 360 today on behalf of Campaign Legal Center. Campaign Legal Center supports AB 534 for the many thoughtful reforms it makes to the administration of Nevada's elections. COC supports many elements of this legislation, including the requirement of comprehensive pre-canvassing of mail-in ballots to ensure fast, accurate tabulation and reporting of election results. Additionally, this legislation contains an important and much-needed reform to the voter challenge process, clarifying that the personal knowledge requirement for a voter challenge must be based on first-hand knowledge through experience of facts. This will ensure that eligible voters are not wrongfully disenfranchised by frivolous challenges based on inaccurate or unreliable third-party databases. These important provisions of this legislation provide for a comprehensive package of needed updates to the election code, and we thank the committee and the secretary for their work on this bill. Thank you.
Good afternoon, Chair and committee members. For the record, my name is Noe Orozco. That's N-O-E, accent over the E, O-R-O-S-C-O. I'm the Government Affairs Manager with Make the Road Nevada. We support all provisions of this bill, but real briefly, just want to talk about two. The first one being the one with regards to the jail, being able to vote there. We are part of the Let Nevadans Vote Coalition, and in the last election, we worked closely with Silver State Voices and sending the letters letting folks know that they may potentially be eligible to vote while being in the county jails. And one of the things that the Secretary of State had mentioned, which was just having the mail or requesting their mail ballot. We did get told that there was sometimes, by the time that they had requested their mail ballots, it was already too late. And so we wholeheartedly support allowing them to be able to use the ease. And then very briefly, the second part of it is with regards to when folks are moving within state. We do support that provision as well, as we do have a lot of folks that move either from the south to the north to the south. And so we do ask you to support this bill. Thank you.
Okay, thank you. Seeing no others in Carson City, we will go down to Las Vegas in support of Assembly Bill 534.
Good afternoon, Chair Mosca and committee members. My name is Chanel, C-H-A-N-E-L, Casanello, C-A-S-S-A-N-E-L-L-O, and I'm the campaign manager at All Voting is Local Action Nevada, an organization that advocates for policies and legislative priorities that expand voter access. I'm here to encourage your support for AB 534. This legislation seeks to bolster access to voter registration and voting for individuals within city and county jails across our state through the use of the EASE system. Currently, EASE serves Nevadan voters who are active members of the U.S. Armed Forces, their spouses and dependents, those who are outside the country, those with disabilities, and tribal voters who live on a colony or reservation. A key highlight of this measure is the structure and support it provides to local county officials. We should take all steps necessary to enfranchise Nevadans and promote civic engagement. And through our work with county clerks, they have recommended that the EASE system be implemented in order to make in-jail voting work effectively. Often, detainees are not from the county they're located in. Therefore, their home county would need to print and mail their ballot to them, but ease would make this process more efficient and practical. We also appreciate the Secretary of State for addressing the issue of third-party databases not qualifying as personal knowledge for submitting voter registration challenges. This clarification helps to safeguard voters' eligibility, gives direct guidance for election administration, and limits questionably sourced information for maintenance purposes. In 2023, this legislature passed the In-Jail Voting Bill, AB 286, with broad bipartisan support. AB 534 represents a logical step to optimize our electoral system, promise consistency, and ensure all eligible voters in detention centers have options to exercise their right to vote. We urge you to support AB 534. Thank you.
Thank you. In Las Vegas, and everyone, we're gonna be at ease for a little bit. We have lost the camera feed. We did hear you, so we have your testimony, but we will be at ease while we fix the technical items. Thank you. Okay, thank you, everybody. We still don't have an update, so we'll go into an actual recess. So we are in recess. Okay, thank you everybody for your great patience. We are now back from recess. So when we went to recess, we were on support of Assembly Bill 534 in Las Vegas. We heard the first testifier, so we will go to the second testifier in support in Las Vegas. You may begin when you're ready, and thank you again for everybody's patience and AVH for fixing the issue.
Good afternoon, Chair Mosca and committee members. My name is Priscilla Gomez. That's Priscella, last name Gomez, and I'm the Democracy Manager at Silver State Voices. On behalf of my organization at the Let Nevadans Vote Coalition, I'm here in strong support of AB 534. AB 534 is a thoughtful and necessary step forward in modernizing our election process in Nevada by updating voter registration rules, refining petition and mail ballot procedures, enhancing the testing and auditing of election technology, and improving polling place standards, amongst other important changes. This legislation helps build public trust and ensures that every eligible Nevadan has a fair and equal opportunity to participate in our democracy. At Silver State Voices, we're particularly proud to support the provision that allows a county or city jail to offer ease as a method of voting for eligible Nevadan voters detained in a jail during an election cycle. We believe that ease can streamline the voting process for both voters and staff members of these jails. As an organization that has advocated for rights restoration, we've seen firsthand how empowering it is when people, especially those impacted by the justice system, are given back their voices. By incorporating this in AB 534, the legislature sends a strong message that civic engagement matters and our elections in Nevada should be fair, accessible, and equitable for all voters in the Silver State. I urge your support on AB 534. Thank you.
Good afternoon, Chair Mosca and members of the committee. My name is William Moore, spelled Williammoore. I'm the Nevada Civic Engagement Director with Mi Familia en Acción. Mi Familia en Acción is a civic engagement organization with a mission to build Latino political power through year-round community action. We're also proud members of the Let Nevadans Vote Coalition. I'm here to testify in strong support of AB 534. As we look towards the future here in Nevada, AB 534 ensures that our community continues to be the decision maker in our state. The expansion of ease would mean that people who are affected by the criminal justice system will be ensured their right to be heard. We have seen firsthand how this disenfranchisement hurts our communities and see AB 534 as a logical policy that helps. AB 534 would help protect our elections and ensure individuals have more access to their constitutional right to choose. We need more access, clarity, and transparency, not less. Here at Mi Familia en Acción, we believe that our inalienable rights are integral to growing a stronger community here in Nevada that works for everybody. Thank you to the committee for sponsoring this bill. We urge the committee to support AB 534. Thank you.
Thank you. Oh, keep going.
Greetings, Chair Mosca and the Leg Ops Committee. My name is Jagada Chambers, Jagadachambers. I come into this committee in complete support of Assembly Bill 534. This piece of legislation is dear to me, not only because of how sacred voting was in my household as a child, but for the efforts I have personally made as it pertains to civic engagement for our community members in custody. This legislation expounds on efforts that went into Washoe, Nye, Humboldt, as well as Clark County last year. We do appreciate the consistency out of the Secretary of State's office, making sure each vote is counted, even if that Nevadan may be in custody for a misdemeanor or an awaiting trial. I am appreciative of the Secretary of State's office and their commitment to the Constitution, as well as seeing value in the voices of Nevadans, even during likely their worst moments in life. I know this is not the Judiciary Committee, but please know this is reentry work. Civic engagement is a public safety program. I petition this honorable committee to support AB 534 and its positive impact on our eligible electors in custody throughout the state. Thank you all.
Thank you. And thank you again for your patience in Las Vegas. Okay, seeing no others, we will move to support on the phone. AVH, if you could please open the phone lines for support of Assembly Bill 534. Don't forget to state and spell your name for the record.
If you would like to testify in support of Assembly Bill 534, please press star 9 to take your place in the queue.
Hello, members of the committee. My name is Paula Luna. That's Paula-Luna. I am the Deputy Director of Battleborn Progress, and we are a partner of the Let Nevadans Vote Coalition. I'm calling today in support of AB 534. AB 534 facilitates Nevadan voters' access to the ballot box in numerous ways, and for that reason alone should be supported. Things like relocation should not be a reason for disenfranchisement. We also would like to echo the comments made by other supporters and our partners here today, and we urge this committee to testify and this committee to support AB 534. Thank you so much.
Thank you. AVH, next caller, please.
Chair, we have no additional callers in support at this time.
Okay, thank you. And with that, we will move to opposition of Assembly Bill 534. We will start here in Carson City. We'll have 2 minutes. Don't forget to state and spell your name for the record. It makes it so much easier for our committee secretary. Thank you.
Good evening, Madam Chair, members of the committee. My name is Janine Hansen. I'm the state president of Nevada Families for Freedom. I doubt that the county clerks were consulted about this bill. It usurps more and more authority from our elected county clerks, and I encourage you to talk to them. We oppose all expansion of electronic voting. The Cybersecurity Infrastructure Security Agency, the Election Commission, the Federal Bureau of Investigation, the National Institute of Standards and Technology assess that the risks vary for electronic ballot delivery and return. While there are effective risk management controls to enable electronic ballot delivery and marking, we recommend paper ballot return, as electronic ballot return technologies are high risk, even with controls in place. Electronic ballot return, the digital return of voted ballot by the voter, creates a significant security risk to the confidentiality of the ballot, the voter data, voter privacy, ballot secrecy, integrity of the voted ballot, and availability of the system. We view electronic ballot return as high risk. We also oppose changing the date from March to February for filing. This harms voters. They have to put up with campaigns longer. It harms minor parties in particular because we have to have a state convention before that, and we would be trying to prepare during Christmas for that. It also harms all of our parties to recruit candidates. We have less time to recruit candidates. It harms candidates because they have to spend more time campaigning and more money to campaign. I don't think this benefits anyone. We have other considerable concerns about this, but those are our major ones, and we ask you to reject this legislation. Thank you.
Good afternoon, Chair and Committee. My name is Joshua Skaggs, and I'm the Legislative Affairs Director for the Nevada Republican Party here in opposition to AB 534. Section 2 and 15 of AB 534 would allow inmates in county or city jails the use of an approved electronic transmission system, or EAS, to register to vote or cast ballots during early voting and on Election Day. Detainees would be able to use digital or electronic signatures to complete necessary voting documents. The Nevada Republican Party strongly opposes the expansion of electronic voting systems to additional groups of voters. The EAS system is already in use far beyond its intended scope. If we continue to expand EAS access every single session, we'll end up with a universal online voting system. Are Nevada Democrats working towards universal online voting? Because such a system would have vulnerabilities that could be exploited, such as hacking or tampering with data or other cyber attacks, especially if the systems are connected to the internet. Electronic voting eliminates any possibility of having safe and transparent elections. Instead, the Nevada Republican Party strongly supports the use of paper ballots and in-person voting on a single election day, with voter ID as fundamental safeguards of election integrity. These methods provide transparency, reduce opportunities for tampering, and ensure public confidence in the voting process. At a minimum, we oppose allowing votes to be cast after Election Day, as in our current system. Absentee ballots should be issued only to those with valid excuses with a voter ID application process to maintain strict accountability while accommodating voters with genuine needs. The multi-subject bill with 82 unrelated sections is far too extensive for us to give detailed opposition to all of the objectionable sections in our allowed time, but we want to be on the record as also opposing the provisions of Section 4, 9, 11, 20, 24, 33, 37, 50, and 67. We will submit written testimony detailing our objections to these additional sections. AB 534 as a whole is not acceptable as a multi-subject bill, and we specifically oppose 11 of the 82 sections stated above. Thank you.
Thank you. Seeing no other opposition in Carson City, we will go down to Las Vegas for opposition of Assembly Bill 534. Seeing no one coming to the table, we'll open up the phone lines AVH for opposition of Assembly Bill 534. Please don't forget to state and spell your name for the record.
Thank you. If you would like to testify in opposition of Assembly Bill 534, please press star 9 to take your place in the queue.
Hi, Yolanda Knack, Yolanda Knaak, Chair and Committee. I am asking for a no vote. I can just ditto what Joshua Skaggs, Mr. Skaggs talked about, and also what Mrs. Hanson talked about. Also, I'm interested in legislation that improves election integrity. And this doesn't do it at all. This will make it worse. Thank you so much.
Thank you. AVH, next caller, please.
Good evening. This is Lynn Chapman, LYNNCHAPMAN, and I'm the State Treasurer of the Independent American Party. The UMA Technology had an article this December 2024, and they touched on some of the things some people have been complaining about. Quote, while electronic voting systems can include security measures, they remain vulnerable to cyber attacks. Potential threats include software vulnerabilities, unauthorized access attempts, and hacking. The consequences of a successful cyber attack on an election could undermine public trust in an electoral process. Dependence on technology means that electronic voting systems are susceptible to technical malfunctions, which can arise from software bugs, hardware failures, or even power outages. Such failures can delay elections or, in the worst cases, lead to the disenfranchisement of voters. And we just saw what happens to phone lines when we can't get in to call in for our testimonies. Technology is not always good. Some electronic voting systems, particularly DRE machines without a voter-verified paper audit trail, may not provide a tangible record of votes cast. This lack of paper trail can raise doubts about the integrity and verifiability of election results, making audits more challenging, unquote. Another problem with the bill is the changing of the filing times to the first 2 weeks of February. It causes problems because people are thinking about the holidays, not politics, and trying to recruit candidates or even having a convention during the holidays will be totally impossible. And lastly, people are so tired of political ads now, and if you move the date and make the campaigns longer, all that will happen is that you're going to end up annoying everyone. So please don't do that. Anyway, thank you very much.
Thank you. AVH, next caller.
Good afternoon. This is Oscar Williams calling, OSCAR WILLIAMS, calling from Reno, Nevada. Hello, Chair Mosca. I understand you're sick. I'm sorry you're not feeling well, and I want to thank you for suffering through to hold this meeting. I can imagine it must be hard. Please get well soon. I mean it sincerely. Moving on to my opposition to AB 534. I like the little word change from provisional to conditional because this has actually significant implications to other areas of law. For example, it is the law that all provisional ballots must be counted unless you've got a court order that says you don't have to count them all. Also, all provisionals are required to be canvassed. So if they're not provisional ballots, I guess those laws just don't apply. That's kind of convenient. We created a whole new ballot type here, a whole new section of voting, I guess, called conditional. I don't think we really need that. AB 534 represents an incremental death of paper ballots and an incremental growth of the top-down tyranny of this secretary. The three little words that stick through it is in every election. Well, in every election, according to Section 19, the counting of paper ballots will be decided by the secretary. Sections 50 and 51, equipment decided by the secretary. You know, there's something called Nevada Constitution Article 4, Section 20, which basically says cities and counties have an enumerated right to conduct and regulate local and township races and their business. This bill, AB 534, is a direct assault on city and county rights in Nevada Constitution Article 4, Section 20. It's quite clear. It goes along the trajectory of this incremental growth of top-down tyranny of the secretary. And that's pretty much it. I'm opposed to it. I think it's unconstitutional. It's going to be challenged. You're just creating a huge headache. It's a behemoth of a bill. As the prior speaker said, it should be split into different sections. As a member of the public, it's daunting. I don't have time to go through 81 sections and pick it apart for you guys, but maybe I could do more writing on that one. It would take me a week. That's all. Thank you for your time, and Chair Mosca, I really hope that you get well soon. Sounds like a bad bug. Thank you so much.
Thank you, Mr. Williams. I appreciate you. Okay, thank you. AVH, next caller, please.
Good evening. My name is Ellen Gifford, ELLENGIFFFORD. Effective legislation provides benefits, solves problems, meets needs, and provides clarity regarding its purpose so that the people it's supposed to serve can comprehend and have confidence in it. AB 543 is not that kind of legislation. This bill seeks to have jailed prisoners using the voting system that was originally established for our revered overseas armed forces personnel and their families. Why, when prisoners already have a process for voting that appeared to have worked fine in the last two elections? If not, there was no transparency there. This bill totally ignores that Nevada law refers to the users of UOCAVA as covered voters, defining the term as a uniformed service voter, an overseas voter, or a spouse or dependent of a uniformed service voter. Jailed prisoner is found nowhere in that definition. This bill seeks to change election terminology that Nevadan voters have long become familiar with for no apparent logical reason. Of course, this means more taxpayer dollars for updating all the statutes and regulations that contain the term provisional to conditional. This bill has 82 sections covering multiple unrelated topics. It's disrespectful to the legislative process. Nevadans deserve better than this. They deserve legislation that is relevant, meaningful, beneficial, well thought out, and well put together. This bill doesn't come close. Thank you.
Thank you. AVH, next caller, please.
Thank you, Chair. We have no additional callers in opposition.
Thank you. And with that, we will move to neutral. Neutral of Assembly Bill 534. We will start here in Carson City. You'll have 2 minutes. Don't forget to state and spell your name for the record.
Hello, Chair Mosca and members of the committee. My name is Ashley Kennedy, spelled Kennedy, representing Clark County. We are neutral on the policy, but did want to come up to just outline a few considerations on the implementations of a few of the sections. I think first I want to touch on Section 20, which relates to mail ballots and processing the same day that they are received. For Clark County in particular, our geographic size is about the size of New Jersey. We have some operational concerns in order to meet that timeline. For our we have done as much as we can to increase capacity to ensure we're picking up mail ballots that are dropped off at vote centers and our drop boxes throughout the day. But there are some vote sites that we will not get to until they are coming back to our warehouse at the end of the night when polls close. For example, in Laughlin or Mesquite. So if we're receiving those ballots maybe by 9, 10 o'clock, processing the same day operationally would be really difficult for us. On election day of this past general election, we received 50,000 ballots on election day. Mail ballots and processing them takes time, and that is something that we are concerned about meeting that timeline. The other two things that I wanted to mention is candidate filing. There's a provision, I might have written this down wrong, but Section 9, to move all the candidate filing to February. While it makes operational sense to have all of judicial and non-judicial candidate filing the same time, one of the challenges that we have is we also have the presidential preference primary. So from a capacity perspective, running the candidate filing for judicial and non-judicial candidates and running the PPP would be operationally difficult for us as well. And then the last thing I wanted to touch on was changing the presidential preference primary in regulation. Now, we understand that this would go through Ledge Commission and there will be a process for that to be handled from an operational perspective. We plan the presidential preference primary about a year in advance. And so we want to make sure that there is some type of timeline in which or a deadline and when the PPP can change so that we can make sure we're planning appropriately. I appreciate the Secretary of State's office for speaking with us and meeting with us, and I'm looking forward to continued conversations. I know we're up on deadline, and we will continue that on the other side, Chair. Thank you.
Good afternoon, Chair Mosca and members of the committee. For the record, my name is Cadence Matijevich, C-A-D-E-N-C-E-M-A-T-I-J-E-V-I-C-H, representing Washoe County. Washoe County would also like to express our appreciation to Secretary Aguilar, his office, and staff for speaking with us about this bill and other bills coming forward to this legislature this session. Washoe County also is in the neutral position. We don't have a position on the policies of the bill, but we do additionally have some implementation concerns that we'd like to share. One of them, and perhaps this is an implementation, but in Section 3, there's a requirement for counties to respond to requests for information from the Secretary's office in 2 business days. And we think it would be appropriate for there to be a reciprocal provision that if county registrars and clerks need information from the Secretary, it goes both ways. We have a great working relationship with the Secretary, but at some point he will have a predecessor, and we'd just like to have that intent clear in the legislation that goes both ways. Washoe County shares the concerns that you heard from Ms. Kennedy with respect to processing every mail ballot that we received on the day that we receive it, and that's based on the specific definition of NRS 293-269933, which is really that we take it all the way through the tabulation process. And so that would be incredibly difficult for us for many of the same reasons. We have polling locations in Wadsworth and Gerlach, particularly in a general election. We could be doing it in winter weather, and sometimes those things don't come back to our election headquarters until very late in the evening. So we just think there's some work there that needs to be done. We understand the urgency. We are interested in getting results out as soon as possible, but want to make sure that we can do that. And then the other thing that I would say, and this is a little bit to the question that Assemblymember Dickman brought forth, that as we continue to work through these things, we may need to ask for some changes or some specific provisions to have have the effective date changed to allow us to implement them. We're already preparing for the upcoming election, and so we may not be able to implement some of these. Again, we know we're at deadline, and that all of this likely can't be fixed before this. Your House needs to take action, so we look forward to continuing to work with the bill sponsor as it moves through the process. Thank you.
Good afternoon, good evening. Amy Bergens, Douglas County Clerk Treasurer, and I am here representing the rural counties. You just heard from the urban counties, Clark and Washoe. We have a lot of the same concerns, so I'm not going to go through each and every one that they have gone through. But I would just say that as the urban counties have said that they have volume issues, the rurals have resource issues. So for the same reasons that they don't like pieces of the bill, we don't like them because we don't have the staff, we don't have the budgets. We cannot ask our 80-year-old election workers to work 24-hour shifts to be able to comply with this. We don't understand how these portions of the bill are going to help with the integrity of the election. We have concerns over it. We feel like, I also want to thank the Secretary of State's office for the cleanup portions of this bill, but I also want to caution that there's a minimal amount of cleanup compared to the amount of changes that are in this bill, and that a lot of the portions of the bill that are not cleanup that were recommended by the county clerks are concerning policy changes that direct power to one centralized state office. And we need to be very careful when we're passing bills this large that we are looking at every aspect of the bill and taking every piece of it into account. So I have, the county clerks and the city clerks have had discussions with the Secretary of State's office about this bill, given them comprehensive feedback on concerns that we have. They have taken that into account and have said that we should be seeing amendments coming forward with some of our concerns as cleanup. So we look forward to that, and I hope that the next time that I am up here, I'm able to support the bill. Thank you.
Hey, Clerk Bergens, if you could spell your name for the record.
My apologies. AMYBURGANS.
Scott Hohen, the Carson City Clerk Recorder, SCOTTHOEN. I just need to ditto what Clark, Washoe, Douglas has just said. There are some significant issues, especially Section 20 on counting the mail ballots, the date that they're received. I mean, I'm not sure if they really understand, from receiving it to do signature verification, to deconstruction, to moving it to our counting board, to actually counting them. It's a long, involved process, and I'm not sure if that necessarily can get done in one day. Moving the dates up for candidate filing into February toys with our presidential preference primary that we have to put on. So we just have two or multiple things going on. I can just imagine what Clark and Washoe have to deal with in terms of the number of candidates that file. There's just ditto everything they said. There's just unintended consequences in terms of some of these things, especially on the staff, especially on the costs. Implementing the top-down voter registration system is going to cost Carson City. We're going to change from $8,000 a year with our old system to $51,000 a year with this new system starting July 1. We have had to implement changes for the DMV system that's been put forth, where the DMV is just automatically registering voters now and not giving people an opportunity to opt out or select party. That all falls on the clerks, and then we have to put out the notices. So our postage bill is going to go up $30,000, $40,000 a year. Staffing requirements to implement that change. There's a lot of this in this that is just behind the scenes, and I hope everything gets worked out. Thank you.
Seeing no other neutral here in Carson City, we will go down to Las Vegas for neutral. And seeing none, AVH will open the phone line for neutral in Assembly Bill 534.
If you would like to testify in neutral for Assembly Bill 534, please press star 9 to take your place in the queue. Caller, please press star 6 to unmute.
Hello. I apologize. I meant to call in under opposition. Is it possible for me to do opposition testimony at this time?
Yes, per our committee rules, we did not reach the 30-minute block, so you can testify in opposition.
Okay, thanks so much. I really appreciate it. My name is Katie Banuelos. It's Banuelos. I'm calling to represent the Libertarian Party of Nevada. We have a lot of concerns about this bill, and we oppose it because the moving the filing deadline for candidates up to the first Monday in February is going to give us a lot less time to prepare to host our convention. It's going to make the campaign season longer, and we think it's going to negatively impact our party as well as other third parties and just politics in general in this state. And so we oppose this bill. We'd like to ask that you vote against it, and I appreciate your time. Thank you.
Next caller, please, AV.
Good afternoon, Chair Mosca. Thank you. Good afternoon, Chair Mosca, Vice Chair Gonzalez, and members of the committee. My name is Susan Greenhall, SUSANGREENHALGH. I'm the Senior Advisor for Election Security at Free Speech for People, a national nonpartisan nonprofit legal advocacy organization committed to protecting democracy for all citizens. And we work really hard through legal action and advocacy to ensure all voters have access to the ballot so they may participate. But we do not, and we are neutral on all of this bill with the exception of the electronic ballot return clause. While we support policies to enfranchise incarcerated voters, we oppose electronic ballot return for any and all voters because it's just too insecure and cannot ensure that the voters' choices will be counted as cast. We work really hard to make sure people have access to the ballot. And if it's not counted properly on the back end, that's all for naught. So we urge you to remove the clause in AB 534 that would expand electronic ballot return. And instead of expanding electronic ballot return, ask Nevada Legislature to seek to curtail it for all voters. It's well-established, settled science that returning ballots electronically over the internet is dangerously and unacceptably insecure, as has been documented by the Department of Homeland Security, National Institute of Standards and Technology, and others. We don't doubt that the Secretary of State is committed to security, but the fact is cyber attacks are inevitable, and entities with far greater resources than the SOS are successfully hacked all the time, like the CIA, NSA, Office of Personnel and Management. Some of the world's largest financial institutions lose billions with a B every year to online attacks. Just 2 months ago, the FBI accused North Korea hackers of stealing $1.5 billion in cryptocurrency. It's not realistic to expect that the Secretary of State's office would be able to build an online voting system able to withstand determined attackers when the nation's most resource security agencies and banks fall victim to online attacks all the time. Because and it's undeniable that Nevada's elections are a valuable asset and would be a target a target of cyber attacks. Because of the unsolvable security threats, the federal voting assistance program at the Department of Defense.
You are at 2 minutes. You could please turn in your testimony. And per the committee rules, that's actually opposition because you oppose a piece of the bill. We will move it. Thank you. AVH, next caller, please. No problem.
Thank you, Chair. We have no additional callers at this time.
Thank you so much. With that, I will invite the Secretary of State's office up for closing remarks.
Thank you, Chair Mosca, members of the committee. I just wanted to address a few things. As the clerk said, we look forward to working with them on amending several provisions of this bill. I do want to touch on the security of ease. Ease is not the transmission of a ballot over the internet. I know that not everyone was on interim ledge ops and elections where Deputy Voloshin walked everyone through the very complex nature of how Ease is built, but I do want to get on the record that the Department of Defense has reached out to the state of Nevada and said that the way that we do our UOCAVA system, which is what Ease is a model for the country that they would like to study further. Just wanted to get that on the record. Thank you.
Chair Mosca and the committee, Cisco Aguilar, Secretary of State, thank you for your time this afternoon. I appreciate all the comments from our clerks. I do understand there's a difference between our urban counties and our rural counties, especially when you talk about Clark County. Clark County had 99% of the ballots on hand this last election cycle. They didn't have the capacity to manage those 50,000 votes to be counted and processed and tabulated. However, we recently met with the county manager, the registrar, to discuss capacity. And their testimony today was a bit disappointing, given the fact that they could increase their capacity even more. They could streamline their systems, develop new systems to be able to process those votes. So I appreciate it. I look forward to continued conversations. Thank you. Have a great evening.
Thank you. And with that, we will close the hearing on Assembly Bill 534. Thank you, everybody, for your patience today. And our last item of business is public comment. Each person has 2 minutes to provide testimony, and written public comment may be submitted to the committee up to 24 hours after the meeting. Members of the public may comment on anything related to legislative operations and elections, but not on any of the bills we heard today, because those bill hearings have been closed. So I'll remind everyone of the call-in number, 888-475-4499, and the meeting ID is 835-8899-2343. Anyone here in Carson City for public comment? Seeing none, we'll go to Las Vegas for public comment. AVH, we will open the phone line for public comment.
If you would like to provide public comment, please press star 9 to take your place in the queue.
Thank you for giving me just a few more minutes. This is Ellen Gifford. I'd just like to state that United States Code states whoever interferes with any person qualifying or acting as a poll watcher shall be fined or imprisoned. Nevada's Constitution states each voter who is a qualified elector and properly registered to vote has the right to have questions concerning voting procedures answered and to have complaints about elections resolved fairly, accurately, and efficiently. This is repeated in the Nevada Secretary of State's Voters' Bill of Rights. NRS 293274 states members of the general public shall be allowed to observe the conduct of voting at a polling place. Allowing public observance of the election process is declared to be the law in no less than 7 Nevada revised statutes. Nowhere in these documents and statutes does it state that someone who wishes to observe the people's election process must disclose their party affiliation, nor is it mentioned that seating for the public will be limited to 3 people, 1 for a Democrat, 1 for a Republican, and 1 for nonpartisan citizens. Yet in the past general election, such limitations existed at various poll locations, with citizens being prohibited from observing their election process. Acts of this nature towards citizens who wish to view the people's election process are a form of intimidation and in violation of Nevada law. Nevada's legislators must address these unlawful acts with legislation that declares these acts as a Class E felony, commensurate with NRS 293710 and NRS 293705 in support of the rights of Nevada citizens. Thank you.
Thank you. AVH, next caller, please.
Thank you, Chair. The public line is open and working. We have no additional callers for public comment.
Okay, seeing no others, we will close public comment. Members of the public, our next meeting is tomorrow at the call of the chair here in our regular room. So make sure you keep an eye on that. And seeing no further business before us, this meeting is adjourned. Thank you.